Hi, I'm Jeff Mersacci, estate planning attorney out of Raleigh, North Carolina with offices in Asheville. And I'm here today just to talk about some of the basics of revocable living trusts. Now, a question I always get is, Jeff, how did you get into this field to begin with? Well, like a lot of people, there was actually some influence by my family. It's not like I came from a family of lawyers. In fact, I came from a family where my father's a doctor. But really, it was between when I graduated from undergraduate, before going away to law school, that I found estate planning ended up being the area I was going to go into. You see, my grandfather died just about a week and a half before I had to load up the car and drive out to law school. And it really was a big traumatic thing. You see, my mom died when I was 9, and my grandparents on my father's side, without a second thought, dropped everything, moved in with us, and they helped raise me and my sister. And so that really was a big thing that my grandparents did for me. And then my grandfather died. My grandmother was starting to have trouble with the estate. You see, she called me on my second day of law school. In fact, I think she probably would have called me the first day, but she figured I was getting orientation. She figured I had to actually walk through the doors once to get all that knowledge dumped into me before she thought I knew everything and started to call up and ask questions. You know, she's a proud grandmother. That's what she did. That's what she did. So she started asking me questions about what was going on with my grandfather's estate. And the reason she was asking me is because she would get billed every time she would talk to the attorney. So she was asking me questions and trying to get background. But you know, she always said the same 3 things every time we talked. I don't understand why this is taking so long. I don't understand why this is so expensive. I don't understand why this is so frustrating. I thought we did everything right by doing wills. And as it turned out, it wasn't the best thing that they could have done. And so for about 1.5 years, I kind of gave the same answer that about every first-year student gives to any question they don't know about law. I don't know, let me look it up in the law library. So I became well acquainted with that law library, and I started finding answers to her questions. But after a while, after this dragged on for a while, I started trying to think, how can this be avoided? This can't have to happen every time somebody passes on. It can't have to be this way. And it turned out it wasn't. But I couldn't find anything in the books. I finally went to the law librarian and I said, this is what's going on. How could this have been avoided? He said, I know exactly the book you need to get. We don't have it here. Go over to the Roosevelt Field Mall and pick up this book called The Living Trust by Henry W. Apps III. Nice, big, thick book. Well, for first-year law students, 400 pages is just kind of like light reading. So I got the book and I started looking through it. It really didn't take long for me to realize why this book wasn't in the law library. Do you know how much money attorneys make off the probate process every year, handling all the court stuff around someone dying? Well, the total cost was somewhere in the range of about $25 billion. That's billion with a B. And that's why this book wasn't in the law library. Why avoid all those problems when it was something that attorneys were actually making a lot of money off of? Well, I decided that avoiding probate, and as it turns out, a revocable trust is a great way to do that, that was going to be a part of my practice. And as it turned out, it ended up being the main part of what I do with my clients. And so for the longest time, I kept saying, okay, you got to read Henry's book. It's a nice, big, thick book. Nobody really wanted to read it. So after a while, I broke down and I finally said, okay, I need to write my own book. And so I wrote The Anti-Probate Revolution. And in this book, I kind of go over a lot of the same things that Henry Apps does in his book. But I kind of really boiled it down, used a couple of stories, left out a lot of the math and other examples, and got it down to about 70, 80 pages. So a much quicker read for my clients. So now this is actually kind of required reading before we meet for that first estate strategy session with new clients. but I do cover the same 4 big downsides for probate that Henry covered in his book. First, probate is expensive. It costs money to go through this court process. Generally, it's about 4 to 10%, and that's based on some numbers with an AARP study, as well as kind of what I've seen in my practice. Between 4 and 10% of an estate gets eaten up by various costs and expenses like appraisals, accounting paperwork, and a large part money that's going into the attorney's pocket for handling all this paperwork and getting everything for the court. That's a lot of money. That really is a lot, and it doesn't have to be that way. Second big downside for probate takes time. Generally, probate takes about 6 months to a year and a half. And, it's really nothing for an estate to go 2 years. And it just kind of drags on and on and on. Now, I hear from a lot of attorneys that, probate's no big deal. Well, I think there's kind of a disconnect there between what the attorneys think is a big deal and what the clients and the families think is a big deal. If an attorney is doing a lot of corporate litigation or medical malpractice cases or all these other things, that takes a lot of time and it's a lot more costly and expensive compared to probate. That's still pretty expensive, but from their point of view, 6 months to a year and a half, no big deal. That's compared to their stuff. But 6 months to a year and a half is an eternity for the family. Now, I always remembered something my grandmother told me when we got at about the year and a half mark and it looked like things were going to be finally done. She said, I just have this gnawing feeling in the pit of my stomach that my house isn't really mine until this whole thing is over. No one should have to feel like that. And so using a trust to avoid that would have been the best thing. Third big downside, probate is more open to being contested. So if it's a will taking things through probate, it's more open to being contested. Why? Right. Here's the secret, and you usually don't hear this in seminars. Because probate is cut out of a trust process, you can't contest the trust in probate. If someone wants to contest a will in probate, all they have to do is file some paperwork, kind of like raise their hand and say, I'm not happy with what's going on, and everything comes to a grinding halt until we figure this thing out. And what's very, very, very likely to happen is all the attorney's fees from all the parties get paid out of the estate, because that's the whole philosophy of probate. Let's make sure we get the beneficiary percentages right. No matter how long it takes, no matter how much money it costs, no matter how much in legal fees gets eaten up, let's make sure we get the percentages right. And so someone goes to an attorney and they say, well, I want to contest this will. My sister's getting 60% and I'm only getting 40%. I think, my father wasn't in his right mind. He told me everything was going to be 50-50. The attorney, yeah, sure, okay, we'll take a shot. And the attorney knows they're very, very likely to get paid. With the trust, it's a whole different ballgame, because now you're not talking about that structured process in probate court. You're talking about filing a civil lawsuit against the trust. You're talking about actually having to file a lawsuit, which now the attorney who's taking it on, they're not almost guaranteed to get attorney's fees out of that. And so someone comes in, my sister's getting 60% of this trust, I'm only getting 40%, I don't think this is right, Dad wanted me to get 50%, and blah, blah, blah. Okay, fine, that's probably going to be about $15,000 for us to get started on that. Oh, no, you get paid when I get paid. No, it's not going to work like that. That's one of the big reasons why it's harder to contest a trust. You're not going to get an attorney to take it on, quote, spec. They're going to have to get paid up front. And people who want something that they're not entitled to are not very likely to put up their own money in order to get it. So that's the third big downside for probate. It's more open for things being contested. Fourth thing, privacy. And this is more of an issue each and every year. I have some clients that it just scares them when they find out what information from their parents' estate was completely open to the public. When you go through probate, an estate has to list on the inventories every bank account, every stock account, every piece of real estate, the date of death values for all of those items, the names, ages, and addresses of all the beneficiaries, and it all gets filed with the court. And because it's a court filing, anyone can look at it. Anyone can write down that information. Anybody can see who's getting what. Now, I had a client, and this is going back quite a few years. He actually called me up and he said, "Jeff, I got a Friday afternoon question for you." That was kind of his way of saying, "Yeah, I'll ask you as long as you don't bill me." I said, "All right, fine, go ahead, tell me." "You know, my dad died in Michigan about 4 months ago. Does that have anything to do with the fact I'm getting all of these brochures from Mercedes and BMW?" Yeah, it probably is. They probably got your name off the probate filings. They see you're going to make a whole bunch of money, and they want to be first in line to help you spend it. Isn't that nice of them? Well, most of my clients just aren't comfortable with that. And then marketing aside, there's also the opening up for things like fraud. There's actually a pretty big increase in fraud, particularly for seniors in their late 80s or 90s or older who pass on and their kids aren't local. And what happens is some scam artists will start submitting fake bills for plumbing work they never did, roofing repairs and stuff that they never did. So they're looking to get paid as a creditor when they never actually did anything. And it's because all that information was there in the file that they started to see what was going on and say, let me try to get a piece of that. So that's, it's just keeping that information private and for the family is something that most people want, and revocable living trust can do that. Right, now what exactly is a revocable living trust? What's the best way to think about it? Well, when you're talking about a revocable living trust, the easiest way to think about it is you think about it kind of like a corporation. You're setting up this trust. It's going to say who's gets what and at what age and all those different contingencies and things that you normally think about in a will. It's going to be in the trust, but you're the trustor. You're setting it up. You're the trustee. You're managing it. You're the first level beneficiary, but you have your assets titled in the name of the trust. And that's actually the secret to this. Probate only grabs a hold of what is still titled in a deceased person's name, go through all of these process, all these inventories, getting receipts and cancel checks and all this other stuff and fill all that up. And on the other side, it just retitles the assets to the proper beneficiary names. That's all. So probate is nothing more than a big, elaborate, time-consuming, frustrating, and very expensive retitling process. So that's what probate is. With the trust, because you're putting your assets into the name of the trust, or you're setting up the beneficiaries the right way, it avoids that whole court process because the accounts aren't titled in the trust. They're titled in the trust, not in the individual's name. Now, how do you really think about and get your head around this concept? Think about it like a corporation. If you're the only shareholder on this corporation, you're the only member on the board of directors, you're the only corporate officer, do you control everything? Yeah. Is the building that you leased, is that leased in your name or the name of the corporation? Oh, it's in the name of the corporation. What about all your inventory? Is that in your name or is it in the name of the corporation? Oh, it's in the name of the corporation. What about the bank account where you deposit all your money that comes in and then pay the bills that go out? Is that in your name or the name of the corporation? What's in the name of the corporation? But do you control everything? Yeah. Is it yours at the end of the day? Yeah, it is. But that's not what's on the checking account. That's not what's on the lease. That's not what's on the inventory. That's enough to keep it out of probate for a trust, but you still keep 100% control. All right, now I just want to make a couple of very quick points about, I hear joint property with a right of survivorship is a great way to avoid probate. Well, yeah, it depends. It really depends. When you're talking about two spouses and they want to put their names on a house or on a stock account with a joint with a right of survivorship, or in North Carolina it might be called tenancy by the entirety, it automatically goes to the surviving spouse. That may be fine depending on the tax situation. It may not be depending on the tax situation, but that's fine. What happens though is I get a lot of widows and widowers who say, oh, this was so easy when my spouse passed on, let me just put the kids' names on everything. And that's where the problems start. First, you've probably heard of the federal gift tax. If you give away more than a given amount in any given year to a person, you have to file a federal gift tax forms. And if you don't, well, there could be interest and penalties for failure to file the tax return and all this other stuff that goes along with it. Well, if you put your son's name on your house, you've given him half the equity in the house. And that could very quickly get over, this year it's $14,000. That could very quickly get over that $14,000 amount. And most people, when I ask them, oh, did you file your gift tax return? And they say, oh, I just put my kids' names on everything. They give me a blank look. So that's one issue. Second, it's theirs. Half of that house now belongs to your son. You can't sell the house without their permission. And even worse, if your son gets into a car accident and it's his fault and there's a big judgment against him, that could be an issue. That actually happened to, a client of a colleague of mine down in Florida. A woman came in and said, look, I want to get this thing set up so that we have everything, I want the deed to my condo in my daughter's name so she gets it. Well, he said, well, okay, why do you want to do this? Well, I want to avoid probate. I want to make sure she gets control of it. If I get sick, well, okay, well, we're talking about a revocable trust is the way to do it. And we set the trust up and we do, oh, no, that sounds too complicated. So she went to another attorney. The other attorney, being a good attorney, sat down and said, oh, what do you want to do? Well, I want to put my daughter on the deed to my condo. Oh, well, why? And he went through the same thing, use a revocable trust. No, that's too complicated. I don't want to do that. She went to a third attorney. You get where this is going? She didn't want to hear the right answer. She wanted the answer she wanted to hear, which she presumably got from another attorney. Put the daughter as a half owner on all of her assets, including the condo. The daughter did get into a car accident, did get sued, did lose, did declare bankruptcy, and now mom ended up having her condo sold out from under her by the sheriff's department at auction, and she got a check for half the proceeds. That wasn't enough for her to get started. She had to actually move in with her daughter after all that. So that's not the result that anybody wants. And there's always the possibility of theft. I hope that none of my clients have anything like that happens with the kids, but if they're joint on a bank account, they can get to the money and just take it and do what they want with it. There's no fiduciary accountability there. So those are just some of the main points to go over with a trust and why joint property may not be the best way to handle things. But really the best thing to do, read through this. If you really have the patience for it, you might be able to still get a copy of Henry's book, The Living Trust, online or at Amazon. But yeah, just wanted to make sure that we had some good information out there on revocable trusts. And if you need anything, give our office a call. Thanks.